Okay, good afternoon. Good afternoon, everyone. This is Dean Gemy Lito Festin of Polytechnic University of the Philippines, or PUP College of Law. I hope you are all safe and healthy. This COVID live lecture series is sponsored by the Philippine Association of Law Schools. It's an association of law deans in the Philippines. And I would like to thank our president, President Dean Mary Ananias, for spearheading this project, and all the deans who are also very, very supportive. I'd like also to thank our PUP President, Dr. Manuel Muhi, and our Vice President for Academic Affairs, Dr. Emmanuel Guzman, for allowing me to lecture and supporting also the Philippine Association of Law Schools project. Before we start, let me share to you what is in my heart. These are times of uncertainties. There's much confusion and insecurities. We worry a lot about our families and our loved ones. And even as our deans are not spared of this feeling and emotion. So just look at your Facebook and you know what I mean. But we set it aside and we give you this project because we believe in you and in your dream of becoming a lawyer. Make the most of your time. There's no shortcut in becoming a lawyer. And we want you not to lose your vision. You can become a lawyer, okay, mind you. So just have the proper attitude and don't allow the fears to grip into your hearts. Because for us, had we allowed it, then we would not have this lecture series and we'll just worry about everything. But we would like you to know that we are here to support you, that we deans are here for you. So before we start in prayer, I would like to start in prayer. Allow me to quote to you the promise of God written in the Holy Scripture. For I know the plans that I have for you, declares the Lord, plans to prosper you, not to harm you, plans to give you hope and a future. So God has a plan for us. He has hope, and you have a future, and you will prosper. So let's bow down our heads and let's pray. Lord, thank you for this opportunity. Thank you for this day. We pray that you will give us wisdom, knowledge, and understanding as we discuss criminal law, common types of questions, and also possible sources of answers in criminal law. And we thank you for this day. We glorify your name. In the name of Jesus Christ, our Lord. Amen. Yeah, so we start. Well, most of you know me, but not in criminal law. So you have my book in special proceedings, and or also the arbitration law or the alternative dispute resolution. But you know, criminal law is my passion. Okay, you have your handouts. I hope you've read it, and exercises also. So I'm not really fond of lecturing here at the small cell phone screen in my room. So, pwede ba lecture type na lang, tutorial type na lang ang style natin? It's like advising or tutoring you, kung pwede. Okay? So, let's see. Let's start. Usually, if the question is situational, okay lang if it's X and Y. Basic. Sana nakikita nyo. Basic. X and Y. X is the accused, Y is the victim. So, what crime did X commit against Y? Very basic lang yan. Okay? Dapat Ngayon, kung gugustuhin natin, mas medyo complicated ang tanong, X, Y, and Z as against A. Okay? X would be a minor, Y of age, Z would be the son of A. This is the father. So they killed they have murdered the father. So intent to kill, there's a qualifying circumstance of treachery. Notice that even if they all committed the crime, okay, yet you have to consider the personal circumstances of this person. Minor, assuming he's 14 years of age. Is he criminally liable? Not. Why? Because according to our Juvenile and Justice Welfare Act, if the age of the minor is 15 years old or younger, it's exempting. There's no criminal liability. Then Y is of age, since there is a qualifying circumstance of treachery, his crime would be murder. But what about C? The son of F. It's not murder. What is the crime? It's parricide. Right? So you can glean from here, the consequences are different because of their circumstances as well as their relation with the offended party. So let's complicate this more. X, Y, Z. Okay, these are the offenders. And you have A, B, C, the victim. Sana nakikita nyo. So, A, pahirapan natin, A would be a person in authority. Okay, B would be the minor, and C would be of age. And X, Y, and Z. The X and Y killed A, Z killed B and C. Labo-labo na sila. Diba? So, A would be a person in authority, so it could result not only in a simple crime, but it can lead to a complex crime. If he's killed, if he's murdered, it could be a complex crime of murder with direct assault. Kung minor, it could be related also to the anti-child abuse law. Okay? So, ganun. This is what we will be discussing later on. So, common types of questions in criminal law. Number one is, what is the crime committed by A? Or what are the crimes committed? Or for what crime is X liable for? Pare-pareho yan. The second type of question would be, what is the participation of A, B, and C? So that will call for what? The participation, whether he's a principal, accomplices, or accessories. Okay? Number 3. What is the criminal liability of X? It does not call for what crime is committed. Nakalagay lang in general. Is X criminally liable? It will probably fall under Article 4 of the revised Penal Code. Then lastly is the presence of, considering the presence of the modifying circumstances or the attending mitigating and aggravating circumstances, what will be the penalty imposed? Or applying the indeterminate sentence law or ISLAW, what is the penalty to be imposed. So yun. So if let's go to the first type of a question. What crime is committed, or what are the crimes committed, or for what crime is X liable for? Then the possible sources of answers, then check on the following rules and principles. What about you check on the elements of a crime? Walang problema yan kung simple lang yan, kung special penal law or crimes punished under the revised penal code. Or if it's punished under the revised penal code, whether it's dolo or culpa. Also, next, tingnan nyo yung distinctions and similarities of crimes punishable under the revised penal code. Robbery, theft, estafa, murder, homicide, magkakamag-anak sila. Similar but not identical. Then check also if it is a complex crime. You know what a complex crime is. Diba? Compound complex crime and complex crime proper. We will discuss that lengthily later on. Number 5, also this you've got to remember the distinction between crimes punished under the RPC and the special penal laws. Or probably, pag tinanong kayo, is there a crime committed? No crime is committed. Why? You check on the justifying and exempting circumstances. In these two instances, diba, there is no criminal liability. Exempting like minority or insanity. Or perhaps you consider also certain principles. In nullum, crimen nulla, poena sine lege. There is no crime when there is no law punishing such act. Sumasagot kayo yung pala. Walang crime committed because there is no law that punishes that particular act. Or perhaps we apply the theory of absorption. Sa rebellion, diba? Common crimes are committed in furtherance of rebellion, then it is absorbed with the crime of rebellion. And check also on Article 332. If the crime is theft, estafa, malicious mischief, committed by particular relatives, spouse, ascendants, descendants, the brothers and sisters living together, or brothers-in-law, brothers or sisters-in-law living together, or widowed spouse also, then that could be an exempting circumstance. No criminal liability. Now check also on the characteristics of criminal law. The generality principle, the territoriality principle. The crime, there's a crime committed, but the crime is outside the jurisdiction of the Philippines. It's in another jurisdiction, or prospectivity. Also, you check on whether there's instigation. No criminal liability in instigation. Also, check on the stages of the crime. Pag sinabing what crime is committed, dalawang factor yan. The crime itself or the stage of the execution. And the stage of the execution. Is it an attempted homicide? Is it a frustrated homicide? Or consummated one? So you've got, it should be within your fingertips, the differences between these three. So yun ang possible sources of answers if that is asked. Then, if you check on the situational essay type of questions, may question B, what is the participation of A? How about B? How about C? That means to say, you have to recall the persons criminally liable under Articles 17, 18, 19, who are the principals, accomplices, as well as the accessories. Another common bar question in criminal law. Is X criminally liable? It does not ask for what is a crime committed, but in general, is X criminally liable? It will fall under Article 4. Why? Because Article 4 speaks about how criminal liability is incurred. So it could result into what? Paragraph 1 or paragraph 2. Paragraph 1 speaks about proximate cause, which should also result in error impersonate, aberratio ictus, and praeter intentionem. Okay, the second paragraph of Article 4 speaks about impossible crime. These are, of course, there are also other common questions. Ito lang ang apat ng common, pinaka-familiar. Considering the presence of the attending or modifying circumstances, what is the penalty to be imposed against X? Or applying the indeterminate sentence law, what is the penalty to be imposed against him? So you've got to remember the disqualifications on the indeterminate sentence law. Of course, also the importance of determining the minimum as well as the maximum term of the indeterminate sentence. Recall also, because ang ISLAW is both applicable to crimes punished under the revised penal code as well as the special penal law. So you've got to recall the rules under the SPL as well as the RPZ. Of course, do not interchange the disqualifications of ISLAW from that of probation. Probation, there are also certain disqualifications. And when does it apply? So we go to the first question. What crime is committed? What are the crimes committed? What crimes did X commit? Or for what crime is X liable for? Sabi natin, you check on the elements of a crime. So, for example, if it's robbery, theft, or piracy, what is the intent? Common element. There's intent to gain, right? What about murder and homicide? There's intent to kill. So it's not correct to say that in homicide there's no intent to kill. No. Pareho sila. There's intent to kill, except that in murder, of course, you have the presence of what we call as qualifying, aggravating circumstances. When you talk about rebellion, the first thing that should come into your mind, what is the intent? To overthrow the government. In coup d'etat, to seize or diminish state power. In illegal possession of firearms, or even in illegal possession of drugs, illicit drugs, what is the common element? Animus possidendi, or intent to possess. In estafa, of course there are two types of estafa, abuse of confidence and deceit. What is the common element? There's damage, or intent to cause damage as well. In malversation, what is the common element? What is the element? There is misappropriation of public funds committed by a public officer. What about selling of prohibited drugs? Selling, yung kanina possession, now it's selling. You've got to prove the object, consideration, and the delivery. So kahit may payment without delivery, wala pa siyang selling. But in addition to that, it's the corpus delicti. Presentation of the corpus delicti, the illicit drugs taken from the suspect and presented in court. So that is where the chain of custody would apply. The court has to be assured that the illicit drugs taken from the suspect is the same drug that was presented in court. So if there is doubt If it's contaminated, then the case will be dismissed, right? So, kailangan i-prove ng prosecution the integrity and evidentiary value of the item seized, that they have been preserved. So, there have been, di ba, may mga links, several links from the accused, the arresting officer, to the investigating officer, as well as to the forensic office, or forensic chemist, and presentation in court. You've got to prove the integrity and evidentiary value had been preserved. Okay, let's talk about dolo or culpa. Alam niyo na yan. So there's freedom, dolo, there's freedom, intelligence. Also in culpa, freedom, intelligence. What separates dolo from culpa? The last element, which is deceit, right? Criminal intent, deceit, bad faith. So what is the proper defense in dolo? Okay, good faith is a proper defense. So ang tanong ngayon, is good faith also a proper defense in culpa? Hindi, di ba? Because what is punished in culpa is the act of imprudence, negligence, lack of foresight, and lack of skill. You may be acting in good faith, but overspeeding ka, you're careless. So what is the proper defense in culpa? Exercise of, alam nyo to, due diligence. Now let me just discuss on dolo. If you're gonna argue, dapat merong mens rea as well as actus rea. Dapat present silang dalawa. They must concur. Mens rea, criminal mind. Actus rea is criminal act. If there's only a criminal mind but there's no criminal act, there's no criminal liability. No internal acts. You can think of any crime for as long as there is no overt act, there is no criminal liability. There is criminal act, but there's no criminal mind, no criminal liability. How does it happen? Okay, if a child 10 years of age stabbed and killed his classmate, 10 years old, is there a crime committed? Yes, there's actus rea. Is there mens rea? None. Because there is no criminal mind, because under the Juvenile and Justice Welfare Act, if the age of the minor is 15 years old or less, then there is no criminal liability. Now you check, as I mentioned a while ago, on the distinction of and similarities of crimes punished under the RPC. But I think we have an exercise. Let's go. Sana you have your exercise also. Your copy of the exercise. So there's a bar question. Dolo. X purchased from Y, owner of a grocery store merchandise. He signed a promissory note for the amount of 500 pesos, 5,000 pesos. Okay, on payable on October 30, 2016. On the date of the maturity of the promissory note, X gave a check with a bank. The same was dishonored for lack of funds. Is X liable for estafa? So this speaks about whether the person is liable for estafa through issuance of a post-dated check. Does it follow that just because the check was dishonored is liable for estafa through issuance of a post-dated check? Now we mentioned that in estafa through issuance of a post-dated check is by deceit and damage. So let's look at the facts of the case. Is there an employment of deceit? When you say deceit, no, simultaneous with the issuance of the check is the employment of of deceit. There is misrepresentation. Sabi niya, okay, I give you the goods and I will guarantee to you that this check is funded. Were it not for that assurance and that guarantee that the check is funded, okay, the victim would not have parted with his goods. Is there an employment of deceit? In this case, there's not. So, ibig sabihin, he is not liable for the crime of estafa. Now, let's about culpa. In the court, so siguro sa funeral procession, I don't have to read all the facts. So, who is negligent, okay? When the people around shouted and gestured, he backed up and ran over the girl, killing the girl. So there's no intent to kill. If you were the parent of the girl victim, what crime would you charge? You would be liable for reckless imprudence resulting to homicide. Of course, sa reckless imprudence resulting to homicide is used in a generic sense. There's no intent to kill. For as long as that results by reason of the exercise of negligence, then it's reckless imprudence resulting to homicide. So let's go back to our discussion. What about distinctions of similar crimes but not identical? We discussed on robbery, theft, and estafa. Robbery and theft, common element is what? Intent to gain. As well as piracy, there's intent to gain. Now, two types of robbery with violence against or intimidation against a person. The second one is through force upon things. So elements, you know this, unlawful taking of personal property belonging to another with intent to gain. And what separates robbery from theft is what? Employment of violence or intimidation or force upon things, which are not present in theft. But with respect to, of course, with robbery, there's what we call as special complex crime. So merong robbery with homicide, robbery with rape, robbery with arson, robbery with intentional mutilation. We will discuss that later on. But there's also robbery with force upon things. When entrance is effected, how? By opening not intended for entrance. Second, by breaking the wall, roof, door, diba? The floor. Why? To effect entrance. Also, by use of false keys or picklocks. Also, simulation of public authority or using fictitious names. These are all employed, okay, to effect entrance. So ang question ngayon, can robbery with force upon things be committed even if entrance was not effected through these circumstances that I mentioned? Halimbawa, invited guest siya. Can he commit a robbery with force upon things? Yes. By breaking nakakita siya ng chest, ng locked furniture, wardrobes, at sinira niya. Or by taking this furniture away to be broken outside. So that's how robbery with force upon things is also committed. Permit me to Okay, what about theft? Theft. Tanggalin mo yung force, violence, intimidation would be theft. Of course, there are also other ways of committing theft, like a finder's keeper. A finder's keeper is a crime. A person found a personal property and he failed to deliver it to the proper authority or to the owner thereof, liable siya for theft. Or if he maliciously damaged the property of another, and he remove or make use of the fruits as well as objects damaged by him. Or when he entered into a closed premises, or trespass is forbidden, or it's owned by another person, and he entered therein without the consent of the owner. So anong ginawa niya? He hunt, fish, gather fruits, cereals, and farm products. So that's also the other way of committing theft. Pero ang pinaka-common is like that of robbery, except that there's no force or violence or intimidation or force upon things. Okay? There's also what we call as qualified theft. What is qualified theft? So, ibig sabihin, pag qualified, higher penalty ang i-mete out. Okay? Number one, if it is committed by a domestic servant, or when there is a grave abuse of confidence, not discretion, confidence. Of course, motor vehicle is taken. So, ang tanong ngayon, sir, may kidnapping. Wala na bang carnapping? Meron. So, what's the difference between qualified theft by taking a motor vehicle from that of a carnapping? Carnapping, motor vehicle is taken without the consent of the owner, or that it was taken against his will by employing violence or intimidation. Pagdating sa qualified theft, no, binigay sa kanya yung physical possession. It was handed to him. Okay? But he failed to return the same. Of course, it can even be a estafa if the person has juridical possession over the same. Sa qualified theft, meron siyang physical possession. Of course, mail matter, large cattle, coconut taken from what? Fish pan? No, coconut plantation. What about fish taken from fish pan or fishery? Or on occasion of fire, earthquake, typhoon, or vehicular accident, volcanic eruption, or other calamities. May lumabas sa bar, vehicular accident. So si A and B, they collided, vehicle A and B collided. Both drivers were unconscious. So here comes a bystander who got hold of the wallet of driver B, who was unconscious at that time. So what crime is committed? It's not simple theft. It's qualified theft. So we discussed about theft, qualified theft. What about estafa? As I mentioned a while ago, there's abuse of confidence and deceit. Common element between the two is that there is damage. So the most familiar sa abuse of confidence is through misappropriation. So the person, this is committed by commission, by trust or administration. He holds the property not in the concept of an owner, but by virtue of commission or trust or administration. Like, for example, if you get items from Avon, so what is the purpose? Is you sell it. Do you own the items? No. Ba? So once you were able to sell it, your obligation is to what? Okay? To remit the proceeds. And then you get your commission. If you fail to sell it, then you have to return it. Otherwise, you can be liable for abuse, estafa. Okay. So let's discuss now on other crimes. Ang magkakamukha. Parricide, infanticide, abortion, murder, as well as homicide. Let me check. Yeah. Basa nyo? Okay. Actually, pabaligtad to. Ginawa lang ng... I don't know how my daughter did this. So, it's robbery. O, tapos na tayo from robbery, theft, and estafa. So, we go into parricide. Okay? Infanticide and abortion. When it's parricide, okay, parricide. How is the crime of parricide committed? Direct line yan, di ba? So it's a direct line. Relatives by direct line. So the killing of a brother and sister cannot be parricide. The killing of the father, the mother, the child. Okay? Killing of the father, mother, child, whether the relationship is legitimate or illegitimate, is parricide. Now, how about other ascendants? Like yung grandparent mo. So the relationship must be legitimate. What about the killing of a grandchild? The relationship must be legitimate. So the only instance, the direct line, whether it's legitimate or not legitimate, is the killing of the father, mother, or child. Of course, there's one. It's also parricide. It's not your relative by blood, but your spouse. Okay, the killing of the spouse. Okay, who must be a legitimate spouse is also parricide. So a proof of legitimacy is required in parricide committed against a wife or other ascendants or other descendants. So if there's also like reckless imprudence committed with these relatives, it's also parricide, but the penalty is lower. Okay? Now, infanticide. Sana infanticide. Yun. Infanticide. The killing of a child who is less than 3 days old. 3 days old. Whether you have a relationship with a child or not, kahit anak mo, but if the age of the child is less than 3 days old, that's also infanticide. Wala naman insecticide. Of course, abortion, which is intentional, intent to abort. Now, ang tanong doon is, there's a bar question in this case. Si husband saka si wife. Okay? H and W. And W was pregnant at that time, 6 months. So they have an altercation, okay, to the point na naging violent. So H pushed his wife, was pregnant at that time, 6 months. So she fell down, and her head hit the pavement. She died instantly. Now what about the child in the womb, the fetus? The child in the womb lived for 6 months. 6 months reckoned from the time that the child was separated from the mother's womb. Ang tanong, what is the crime committed by H? No doubt, namatay si wife, so there's parricide. What about the child inside? Is it abortion or infanticide? Now, recall Civil Code provision. If the age of the child is less than 7 months old, okay, para magkaroon civil personality, okay, the child must live for at least 24 hours reckoned from separation from the mother's womb. So since in this case, less than 6 months, and the child, assuming did not live for 24 hours, the child only lived for 10 hours, then the crime is a complex crime of parricide with unintentional abortion. This is a complex crime. A single act that constitutes two or more grave or less grave felonies. Now, if the age of the child is, halimbawa, 8 months na siya, and the child only live for 10 hours. Kanina pala hours. Kung 10 hours lang siya nag-live, but 8 months na yung bata, it's already parricide, a complex crime of parricide with infanticide. Okay, so now let's go to the difference between murder and homicide. As I mentioned a while ago, there's intent to kill on both instances, right? But the difference is the presence of what we call as the qualifying aggravating circumstances. Di ba alam natin sa aggravating, there's generic, specific, inherent. Qualifying, it changes the nature of the crime. So treachery is a qualifying aggravating. Evident premeditation is a qualifying aggravating circumstance. Of course, cruelty or consideration of a price or reward or promise, or on occasion of fire, poison, or explosion. So, lahat ito included under Article 14, giving instances of aggravating. But there's one qualifying aggravating which is not included under Article 14. What is that? Scoffing or outraging at the corpse. It is a qualifying aggravating in the crime of murder. Pag-treachery. Okay? Two things dapat you have to remember. Number one is that there is no opportunity to defend himself, or the attack is sudden and unexpected. Okay? The victim had no inkling that his life is in danger. So the first one is no opportunity to defend himself, but there's also the second one. It must be consciously and deliberately adopted to ensure its execution, to eliminate self-defense on the part of the victim. Those two must concur. So if the person had the opportunity to defend himself, opportunity lang ito. So halimbawa, he was already forewarned that X was gonna kill him. So his friend advised him to run away. But he was overpowered by B, and B killed A. There's no opportunity to defend himself. There is an opportunity for him to defend himself. So wala siyang murder. The crime is homicide. Okay? Now, evident premeditation. 3 instances. Okay? So there is the time that he actually determined to commit the crime. Second is acts manifestly showing that he clung to his determination to commit the crime. And the third is sufficient lapse of time from the time that he determined to the time that he actually committed the crime. Actually, there's a time for him to reflect upon and meditate upon the consequences of his act. So, hindi sila pwedeng magsama ng passion and obfuscation. Now, what about this scoffing and outraging at the corpse? So, halimbawa, in my first instance, okay, there is an opportunity for him to defend himself. Okay? Kaya lang napatay siya. So, it's homicide, di ba? Kaya lang what the offender did is what? To behead the victim and threw his head to the river. What crime is that? That is murder. And it's not because of treachery. It's because of scoffing or outraging at the corpse. What about the differences between treason, rebellion, piracy, coup d'etat, misprision of treason, sedition, mutiny, terrorism. Treason and rebellion. Okay, treason. This is a breach of allegiance. This is a crime of breach of allegiance. So the offender here is one who owes allegiance to the Republic. Right? So like a Filipino citizen or a resident alien. A resident alien has temporary allegiance to the Republic. And how is this committed? Two things. By levying war and adherence to the enemy, giving them aid and comfort. When you say levying war, what do you mean? Okay? So there's an actual assemblage of people gathered for the purpose of executing a treasonable design. Adherence to the enemy. What is the meaning of that? The offender perform an act which strengthens or tend to strengthen the enemy, or perform an act which weakens or tend to weaken the state or the republic. First, there is also a two-witness rule. To convict a person of treachery, dapat there should be two witnesses to testify on the same overt act. There's also misprision of treason. So if there's treason, there's misprision of treason. If a person has knowledge of conspiracy to commit treason and they fail to disclose that to the proper authority, then liable for misprision of treason. And the person who may commit this crime is a Filipino citizen. If a person has knowledge of the crime of rebellion and he fails to disclose that, is he criminally liable? No, because there's no misprision of rebellion, but only there is a crime of misprision of treason. What about rebellion? As we mentioned a while ago, the purpose is to overthrow the government. Two things, di ba? Public uprising and taking arms against the government. So how will you differentiate that from sedition? There's also public uprising in sedition. What's it? A public and tumultuous uprising. There is no taking arms against the government. This is only peculiar to the crime of rebellion. Rebellion is always political. Sedition is social and also political. What about piracy and mutiny? So piracy, there's seizing of the vessel and also the cargo, equipment, and belonging of persons. Now there's piracy in high seas as well as piracy in Philippine waters. How will you differentiate piracy from mutiny? In piracy, there is intent to gain. In mutiny, there's no intent to gain. What is the purpose? Okay, to disobey the orders of the superiors. Piracy in high seas from mutiny. Mutiny is committed by members of the complement. Okay, piracy committed generally by stranger. But in piracy in Philippine waters, it can be committed by a passenger. Now, there's also qualified piracy. What is qualified piracy? So if the seizing of the vessel is through boarding or firing the same, it's qualified. Or they have abandoned the victim without means of saving themselves. Or third, if it is accompanied by murder, homicide, rape, or physical injuries. In coup d'etat, first thing that should come into your mind, there's a swift attack, coupled with what? Violence, intimidation, threat, or strategy. So, unlike in rebellion, where the purpose is to overthrow the government, the purpose in coup d'etat is to diminish or seize state power. What about terrorism? Okay, under Anti-Security Act. So the first is elements is that there is a commission of a predicate crime which is punishable under the RPC as well as the SPL. But more than that is that it's so, and it create what? A widespread and extraordinary fear and panic among the populace. The third element is to coerce the government to give in to their unlawful demand. So dapat merong demand. So no demand, no terrorism. No demand, no delay sa civil. Sa terrorism, no demand, okay, no terrorism. And that demand must be an unlawful one. So it's really hard to prove terrorism, what is widespread and extraordinary fear. Wala pang definition with respect to exact. Now, what about complex crime? Diba? Complex crime. I think there are questions with respect to distinctions and similarities in the same. RPC, robbery and theft. Sa exercise natin, A broke open a window and without entering the house, took a wooden chest lying just underneath the window. He brought out the chest to the yard where he broke it open and took away contents thereof, all valued at 5,000 pesos. What crime did he commit? So there was a breaking of the door, of the window, but without entering the house. So what is your answer? The crime committed, is it robbery or theft? The crime committed is purely theft. Right? So even if there is a breaking of a window, but he did not enter into the premises, so robbery with force upon things cannot be committed. Arson and murder. B set the house of A on fire by way of revenge against the latter. B did not know that A was inside. A died because of the fire. What crime or crimes did B commit? Second question. Suppose naman that B knew that A was inside. What crime or crimes did B commit? Third question is, suppose before setting it on fire, ang ginawa ni B muna is to enter the house and killed A. And then to conceal the house, then B set the fire on fire to hide the body of A. What crime or crimes did B commit? First question, B would be liable for what? The crime of arson. Special crime of arson with homicide. Somebody died, so the penalty is higher. If B knew that A was in the house when it was set on fire, then the crime is murder. Fire would now constitute as a qualifying circumstance in the crime of murder. If B killed A before the house was set on fire, then two crimes were committed: murder and arson. The arson was committed to conceal the crime of murder. Okay. So let's go to complex crime. Pag sinabing complex crime, there are two types of complex crime: compound and complex crime. Single act constitutes two or more grave or less grave felonies. So ang tanong, just because two crimes are committed by virtue of a single act, is there a complex crime? No. Why? Because those two crimes must be two or more grave or less grave felonies. So when you say grave, punishment is what? Capital and afflictive. Less grave, correctional. Prison correctional, okay, arresto mayor, suspension, and discharge. We also have complex crime proper. Sabi dito, only a necessary means to commit another. Hindi siya indispensable means. If it is an indispensable means, then there is no complex crime. If it is an element of the crime, there is no complex crime. So ang tanong, is there a complex crime of estafa through falsification of a private document? Common element, in estafa, there is damage. In falsification of a private document, there is also damage. Elements ng crime ito. So is there a complex crime? None. Because it is now the indispensable means. Ang complex crime dapat lang necessary means. Okay? How do you differentiate a complex crime from a special complex crime? In special complex crime, two crimes are committed but punished under a single provision of the revised penal code. Ang complex crime, the penalty is what? For the most serious crime, the same to be imposed in its maximum period. Now, ang complex crime is not applicable to special penal laws. Not also applicable to light felonies. Not also applicable to conceal the crime. Remember that. Now, let's go to other distinction and similarities between an SPL as well as the RPC. RPC, how do you distinguish first special penal laws from that of the RPC? In RPC, mala in se, evil in its nature, right? So therefore, good faith is a proper defense. In SPL, it's plain mala prohibita. And good faith is not a matter of defense. So if you're going to ask, if the question calls for a distinction between a particular crime, which is an SPL, and another one, which is an RPC, then you go with the general distinction. Mala in se, mala prohibita. Well, is this an absolute rule? Mala in se RPC? No. May case na, although it's RPC, yet it is mala prohibita. So therefore, good faith is not a proper defense. What is the exception? Technical malversation or illegal use of public funds. What about in SPL? Sabi natin mala prohibita. Is that an absolute rule? No. There are cases, well, although it's punishable under the SPL, it is deemed as mala in se. Like what? Plunder. So, Supreme Court said that it is evil in its nature. So it's mala in se, although plunder is a special penal law. And so therefore, good faith is not a proper defense. Another distinction, stages of executions, principals, accomplices, accessories. Okay? These are applicable to crimes punished under the RPC in order to determine the proper imposable penalty. Sa special penal laws, no. Generally, the offender is regarded as a principal. Unless ang SPL, okay, uses these persons criminally liable or stages of execution. So in stages of execution, consummated, frustrated, attempted, not applicable to SPL. Persons criminally liable, principals, accomplices, accessories, not applicable to SPL. Unless the SPL borrows the same. Generally, it's in SPL, the crime is consummated and the offender is regarded as a principal. Okay. Modifying circumstances. The presence of aggravating as well as mitigating circumstances to offset one from the other. Okay? These are important in crimes punished under the revised penal code to arrive at the proper imposable penalty. Now sa SPL, okay, we do not regard the presence of aggravating, mitigating circumstances generally. So kahit may voluntary surrender yan, diba? May plea of guilt, but if it's an SPL, then it will not be appreciated because it's an SPL. What else? Yung nomenclature of penalties of under the revised penal code. Reclusion perpetua, reclusion temporal. Peculiar lang sa RPC. Sa SPL, okay, the special penal laws provide for a particular penalty. So in RPC, there is reclusion perpetua. In SPL, there is life imprisonment. But what happens then kung ang SPL uses the nomenclature of penalties ng RPC? So, di ba, maraming cases na ang SPL uses the nomenclature of penalties ng RPC. What is the effect? With regard to the application of the indeterminate sentence law. Di ba sa Islao, we follow the rules under the special penal laws. There's also a peculiar rule under this RPC. But if the SPL uses the nomenclature of penalties under the revised penal code, then the rules under the indeterminate sentence law, what? We will apply it under the RPC and not the SPL. So therefore, anong gagawin natin? Okay? There is the rule of offsetting. So we will appreciate the presence of the modifying circumstances of aggravating as well as mitigating circumstances, although it is an SPL. Why? Because it uses the nomenclature of penalties under the revised penal code. What about the difference between BP22 and estafa? BP22 and estafa. One is an SPL, one is an RPC. Mala inse, mala primita. But basic, in BP22, okay, he's given 5 banking days to pay in full the obligation or to make an arrangement in full. In estafa, 3 days lang. Now, ang tanong, is it just because ba when a check is presented before the bank and it was dishonored, ipso facto BP22 is committed? No. Kailangan bibigyan siya ng 5 banking days within which to pay or to make an arrangement to pay. Notice of dishonor. Okay? Notice of dishonor. So if this is not proven, if the notice of dishonor is not personally received by the accused, then there's no BP22. He must be given a chance to pay the same. In BP22, there's pre-existing obligation. In estafa, there's simultaneous obligation. Simultaneous with the parting of the goods is the employment of deceit. Okay, what else? What is punished in BP22? What is punished in BP22 is the issuance of a worthless check. What is punished in estafa? Okay, deceit and damage. So implication, a person can be brought liable for BP22 and estafa. Estafa is harder to prove. Bakit? Because you've got to prove deceit and damage. What about corporation? Corporate officers who sign is liable, but he is entitled to receive the notice of this or honor personally. and not be given to a corporate secretary. Now, according to the Supreme Court admin circular, it did not decriminalize BP 22. The court has the discretion to impose a fine as a penalty instead of kaagad imprisonment. Remember that. Okay? Now, crimes similar, direct bribery and anti-graft. Can a person be both liable for direct bribery as well as the anti-graft corrupt practices under special penal laws? Yes, kasi they have different elements. Right? Sa anti-graft, B-E-G-H. Diba? 3B, 3E, 3G, 3H. 3B, the person intervene in the contract. A public officer entered into a contract in which he has the right to intervene. BE is evident bad faith, manifest partiality, and there is also grave inexcusable negligence. BG is he entered into a contract which is grossly disadvantageous to the government. Grossly and manifestly disadvantageous to the government. And the last one is holding an interest which is what prohibited under the law. These are not the same elements as that of direct bribery. Indirect bribery is only agreeing to perform an act constituting a crime. Sa direct bribery, agreeing to perform an act, wala pang acceptance. Basta ang agreement nyo is what? That which would constitute a crime. Second, acceptance of the gift. Basta to perform an act not constituting a crime. So kanina agreeing, constituting a crime. By mere agreement, consummated ang crime. Sa second instance, there must be an acceptance. Okay? So acceptance to what? To perform an act not constituting a crime. The third one is acceptance of the gift to refrain the public officer from doing something in which it was his official duty to do. So again, let me emphasize that a person can be both liable for direct bribery and anti-graft because the elements are not the same. One is an ISPL and one is under the revised penal code. So also, there could probably no crime committed kasi justifying. One is an exempting. Anong pa similarity between the justifying as well as the exempting circumstances? There's no criminal liability to both. Except that in justifying, there's also no civil liability. In exempting, there is civil liability as a general rule. So justifying no criminal as liability, no civil liability except avoidance of evil, which is provided under paragraph 4. Avoidance of greater evil, there is civil liability. What about in exempting? No criminal liability, but there is civil liability. Is this an absolute rule? There are two exceptions where there is no civil liability in exempting under paragraph 4, which is what? Accident. Paragraph 7, which is what? Insuperable cause. Insuperable cause. Okay? So like minority and insanity, there's no criminal liability. If the age of the child is 15 years old or younger, no criminal liability. If it's above 15, below 18, without acting without discernment, then there's no criminal liability as well. Insanity, except if the person acted during lucid interval like now. Okay. Yun. So, meron din mga chances are that the crime is not punished under the revised penal code. Like there's no misprision of rebellion. You have knowledge of what? Conspiracy to commit rebellion, but you fail to disclose it to the proper authority. Is there criminal liability? Wala. Kasi walang crime na nagsasabing misprision of rebellion. Okay? There's also absorption. Rebellion absorbs other common crimes in furtherance of rebellion. So there's also instigation, and under Article 332 is theft, estafa, and malicious mischief. If committed by spouse, ascendants, descendants, okay, widowed spouse, brothers and sisters, if living together, there's no criminal liability. Now, once you know already the elements of the crime, then you check also the stages of execution, whether it's consummated, frustrated, or attempted. Diba? The crime is frustrated homicide. The crime is attempted homicide. So you got to know what is attempted and frustrated. Of course, you know the internal acts. Okay? External acts. Internal acts are not punishable. External acts are not punishable as well. Okay? If it is a preparatory act, it's not punishable. Acts of execution is punishable. Now, what is the difference between a frustrated and from attempted? In a frustrated, the offender had performed all acts of execution. In attempted, offender had only commences the commission of a crime directly by overt acts, but did not perform, okay, all acts of execution. So what's the difference between the two? Sa attempted, he did not perform all acts of execution. In frustrated, he already performed all acts of execution, which would produce the felony. But in both instances, the crime is not consummated. Why? In attempted, by reasons what? Other than his own spontaneous desistance. In frustrated, what is the reason? Okay? Independent of the will of the perpetrator. So, pagka A pointed his gun against B and he missed, what is the crime committed? It's still attempted. Halimbawa, attempted homicide. If A pointed his gun against B, tinamaan yung kamay niya, what is the crime committed? It's still attempted. Because there's something remains to be done. It's not consummated. Hindi napatay yung tao. With respect to frustrated, okay, he had already performed all acts of execution. So the wound inflicted is what? A mortal wound. It's a fatal wound. So if A shot B on the vital parts of his organ, okay, that's frustrated. Now, the person did not die. Why? Because he was brought to the hospital. Because of timely medical attention. Were it not for the intervention of the doctors, then B would have died. In that case, we can say that he already performed all acts of execution. Okay? So, in these instances, halimbawa, si husband at si wife. Si husband, okay, hindi niya na-love si W. Okay, he planned to kill his wife. So, he's a physician. So, nagbigay siya ng poison sa glass ni W. May poison. Pero, may poison. So, ano nangyari? So, nangisay si wife in his presence. So, naawa si husband. Kasi minsan niyang minahal si wife, di ba? Saka, magulang din siya, mother din siya ng kanyang mga kids. So, what he did is to employ an antidote to the poison. So the wife survived. So ang tanong ngayon, okay, is he liable for attempted or frustrated parricide? So we check on the attempted. Check on the attempted. Did he or did he not perform all acts of execution? He did perform all acts of execution. So wala nang attempted. Okay, was it consummated? So kung frustrated siya, was it consummated? Okay? No, because the W survived. Is it dependent or independent of the will of the perpetrator? It is dependent upon age. So there's no attempted as well as no frustrated parricide. So the crime is merely what? Physical injuries committed. Okay? So tatandaan nyo mga yan. Now, ano pa? What is the participation of A, B, and C? Principal by direct participation, principal by inducement, principal by indispensable cooperation. So sa principal na yon, tatandaan nyo, direct participation, tatandaan nyo, if kung merong conspiracy, all will be liable for all the co-conspirators are liable as principals by direct participation. So ang tanong is mere conspiracy punishable? Mere conspiracy is not punishable. Okay? Unless there is a law that punishes the same. Conspiracy to commit rebellion, sedition, coup d'etat, among others. Bawa, si A and B conspired to murder X. Tomorrow, A will drive his car bringing B to the place of X. And B is assigned to kill X. The following day, only B appeared and killed X. During investigation, it was found out that A also conspired to kill X. So he was also charged with the crime of murder as well as conspiracy to commit murder. Is he liable? No. Wala namang conspiracy to commit murder. Eh sir, paano yun? The act of one is the act of all. Okay? This is not applicable. Pag sinabi mong the act of one is the act of all, dapat may overt act si A. In this case, wala siyang overt act. Si B lang ang pumunta at the scene of the crime. Okay? According to conspiracy, dapat dadalhin niya si B at the scene of the crime, but he did not. Okay? So, A is not criminally liable. So, when you say the act of one is the act of all, lahat dapat he performed already his act pursuant to the plan or pursuant to the conspiracy. A, B, and C conspired to rob X. A, according to their agreement, will bring them to the scene of the crime. B will be the lookout. C will be the one who will rob the house. Okay. Sabi ni A, when charged, sabi ni A, hindi. I only drove them at the scene of the crime. Hindi naman ako nagnakaw. So, dapat si B lang ang personally liable. Okay? Is that applicable? No. All of them would be liable for robbery because it was the act of one and the act of all. It was in pursuant to the agreement. So, they're also liable only for the crime that they conspired to commit. Liable only for the crime that they conspired to commit. So if his act is not part of the agreement, then he will not be liable. Except pag special complex crimes. Robbery with homicide, robbery with rape, robbery with arson, robbery with serious physical injuries. Why? Because in this special complex crimes, okay, it has its own peculiar rule. May peculiar rule siya. By reason or on occasion of robbery, somebody gets killed, then all of them will be liable for robbery with homicide, although the killing is not part of the agreement. Because there's a special provision provided under the IN. So yung robbery with homicide, hindi ibig sabihin that there's intent to kill. Whether it's intentional or not, it's still robbery with homicide. There is no robbery with murder. Robbery with homicide pa din yan. Because it happened before, during, or immediately after the robbery. Dapat lang at the onset, sa simula pa lang, there is intent to rob. And somebody dies before, during, or immediately after the robbery. Okay? Now, kung ang intent nila at the onset is to kill, okay, A, B, and C, okay, intended to murder the victim. And then as an afterthought, yung isang co-conspirator, okay, stole and robbed the jewelry box of the victim. There is no robbery with homicide. So what shall we apply? A person is only liable for the crime that they conspired to commit. All of them will be liable for robbery, but for killing, which is the crime that they conspired to commit. But for robbery, yung co-conspirator lang ang liable. Siya lang ang gumawa nun, but not all the rest. Again, a person is liable only for the crime that they conspired to commit. Okay? Exception is if it's a special complex crime. Robbery with rape, robbery with homicide, etc. Okay? So, sa robbery with rape, somebody was raped by reason or on occasion of robbery. Although rape is not part of the conspiracy, lahat sila magiging liable for robbery with rape. Now, inducement, alam nyo na yun, indispensable cooperation. Indispensable is cooperation must be indispensable. Otherwise, the crime would not have been committed. Now, ang accomplices, you just remember that in accomplices, okay, there's no conspiracy. Kung may conspiracy, principal yan. In accomplices, he only cooperated with the commission of the crime by previous or simultaneous acts. And remember this, his participation is less than that of the principal. Hindi dapat pareho or greater than that of the principal. If the wound inflicted by the principal, by the person is a mortal wound, and the wound inflicted by the principal is also a mortal wound, pareho lang sila. So he's not an accomplice, but he would be a principal. Well, accessories, three instances profited from the commission, and also second, he concealed or destroyed the body of the crime. Second, if he concealed or harbors or seized in the escape of the principal. So dapat, di ba, ang hinarbor niya at ikinonceal niya ay inassist niya is a principal, not an accomplice. Pag accomplice yan, walang accessories. Now you've got to remember also who are the persons who assisted the principal. If he's a private person, na dapat limited lang ang ginawa ng principals. TPMA, treason, parricide, murder, attempt of the life of the chief executive, or he is known to be habitual delinquent. Pag public siya, any crimes committed by the principal, for as long as there is an abuse of his public position. Of course, there are exempted under Article 20. Diba? Mga spouse, ascendants, descendants, etc. But if they profited from the effects of the crime, then they will not be liable as an accessory. Now, perhaps they're not liable, but they can be liable for a special penal crime, which is what? The anti-fencing law. So, under the anti-fencing law, walang exception. Anyone who buys or sells, deals with an object or an item subject of robbery or thievery will be liable for the anti-fencing law. For as long as he knows or he should have known that it came from the proceeds of robbery or theft. So if you're able to buy a brand new book in RPC costing it's a Rex bookstore, it costs around 2,500, and you were able to buy it only at 200 pesos, brand new, liable ka for anti-fencing law. You've got to, yun. So, let's go about on article, halimbawa, ang tanong, is X criminally liable? Is X criminally liable? Pwedeng article 4 siya. Diba? Hindi naman specific crimes. How? Paano nag-apply article 4? By committing a felony although the wrongful act done be different from that which he intended. Okay? The first paragraph pertains to intentional felony. So, dolo lang siya. Hindi siya mag-a-apply sa ibang, sa culpa or sa special penal laws. A person is liable for the direct, natural, and logical consequences of his unlawful act. Now, if we perform a lawful act, then he's not liable kahit may namatay siya. Kasi he's performing a lawful act. Dapat unlawful act lang. Is liable for the direct, natural, and logical consequences of the same. So, pag error impersonate, dapat two persons are present at the scene of the crime. A believing that it was B. A intended to kill B. Pero ang pinatay niya, si C, believing that it was B. Okay? Sa aberratio ictus, there is lack of precision. Tatlo ang present at the scene of the crime. Si A, si B, at si C. Binaril ni A, si B. The bullet ricochet, it was C, who was hit. 3 persons. Sa error impersonate, 2 ang present. Okay? Praeter intentionem, the resulting injury is greater from that which they intend to commit. Now, impossible crime. Impossible crime by performing an act which will be an offense against persons or property. So, this is only applicable to persons and property. Okay? Secondly, dapat it should not constitute a crime punishable under the other provisions of the revised penal code. Okay? So there's legal impossibility. There's also physical impossibility. You cannot kill a person who's already dead. So A intended to kill B, believing that B was already is still alive, but unknown to A, okay, B was already dead beforehand. Why? Because he suffered heart attack. So sinaksak niya si B. Patay na pala si B. So that's an impossible crime. But if A knew that B was alive at that time, there's no impossible crime. Okay. So we go into the other. We can already discuss penalties. Okay. We will be discussing on the indeterminate sentence law. So pagtanong, considering the presence of the attending modifying circumstances, what is the penalty to be imposed against X? Or applying the indeterminate sentence law, what is the penalty to be imposed? So dapat alam nyo ang islaw. Importance ng islaw from that of probation. Okay. you've got to set the minimum term and the maximum term of the indeterminate sentence. Why? Because once the convict, we're talking about the convict here, had already served the minimum term of the indeterminate sentence, then he will now be eligible to be released on parole. Then why do you have to determine the maximum term of the indeterminate sentence? You've got to determine the same so that if in case the convict violates any of the conditions of his parole, then he will have to serve the maximum term of his indeterminate sentence. So probation law, he doesn't have to go to jail. He only have to what? To report to the probation officer and meet the conditions of his probation. So magkaiba silang dalawa. Okay? So hindi ma-imprison sa probationer. Let's go to Islao. Okay, disqualifications. You don't even have to compute pagka-disqualified siya. Just memorize the disqualifications. Number one, the penalty imposed is a death, reclusion perpetua, or life imprisonment. Remember that sa indeterminate sentence law, it is both applicable to what? RPC and special penal laws. Okay? Tandaan yun. Of course, he's been convicted of treason, lahat ng treason, misprision of treason, conspiracy to commit treason, rebellion also is a disqualification, piracy is a disqualification, if he is a habitual delinquent, or if he escaped from imprisonment or from his sentence. Tatandaan yun. Minsan, sa bar question lumabas dyan. Nililito ka if a person is a habitual delinquent. Tapos may maliit na sentence na nakalagay doon. Ano nakalagay sa sentence? He escaped from imprisonment. Dinidetermine po siya if he's a habitual delinquent or not. If period of 10 years, diba, he committed from his last release or conviction, he committed robbery, theft, estafa, less serious physical injuries, and falsification a third time or oftener. At second time lang siya. So you concluded, no, hindi siya disqualified, magko-compute ka. But then nakalagay doon, he escaped from imprisonment. Disqualified siya. And also, those whose maximum term does not exceed 1 year. So, hindi ka mag-i-islaw, hindi ka mag-apply ng 2 months minimum term to 5 months maximum term. No. Kasi you will not apply the indeterminate sentence law, you will not impose the minimum term as well as the maximum term of his indeterminate sentence if the penalty is less than 1 year. So dapat straight penalty ka lang. 6 months imprisonment, tapos. Or 5 months imprisonment and 1 day. Walang minimum and maximum term. Now, if the penalty exceeds 1 year, then the court is mandated to impose the minimum term as well as the maximum term of his indeterminate sentence. So, ang court hindi pa pwedeng mag-impose siya ng penalty of halimbawa, Comprehensive Drugs Act. Ang penalty imposed there is only 3 years and 1 day. Period. Mali. Dapat the court has to set the minimum and the maximum term. Now remember, maximum term and minimum term. Hindi minimum sentence, hindi maximum sentence. Mamamali kayo sa bar exam. So, how do you get the minimum term and the maximum term when the penalty is punishable under the revised penal code? Under this special penal laws lang, mas madali mo ng SPL. Now, remember, sa SPL, we do not regard the presence of any mitigating as well as aggravating circumstances. So, So kahit merong passion and obfuscation dyan, voluntary surrender, we will not consider the same. Okay? So, simple lang yan. How do you get the minimum term and the maximum term to crimes punished under the SPL? Okay? So, sa SPL, sa bar questions, magpo-provide ng penalty imposed by the law. And then, penalty imposed by the court. So, ang tanong, is the penalty thus imposed by the court, okay, proper or not? Proper or not? So, halimbawa, sa illegal possession of firearms, the penalty is 5 years minimum to 10 years maximum. Okay? Assuming 5 years to 10 years. How do you get the minimum term and how do you get the maximum term? Ang sabi ng batas, it should not be the minimum term should not be lower than the minimum imposed by law. So it should not be lower than 5 years, right? Now, how do you get the maximum term? The penalty should not exceed the maximum penalty imposed by the special penal laws. So kung 10 years yan, it should not exceed 10 years. So, anywhere in between 5 years and 10 years, okay, pwede. Pwede. So, walang rule of offsetting. So, remember that in SPL, two things. The penalty imposed by the law. Illegal possession of firearms, 5 years to 10 years. And then the penalty imposed by the court. Is the penalty thus imposed by the court proper or not? Okay, ang tanong mo, minimum term, how do you get the minimum term? It should not be lower than the minimum sentence fixed by the SPL. Kung 5 years yan, hindi bababa ng 5 years. Again, if it's a maximum term, it should not exceed the maximum penalty imposed by the special penal law. Anywhere in between 5 years to 10 years is proper. Kung merong 11 years dyan, not proper. Kung may 4 years, 3 years dyan, not proper. So that's only simple. And so far as SPL is concerned. Now let's go to the revised penal code. Sa revised penal code, how do you get the maximum term and the minimum term of the indeterminate sentence? There is the rule of offsetting. To get the maximum term of the indeterminate sentence, apply mo yung rule of offsetting. Now remember, let's discuss first. Sa rule of offsetting, anong ino-offset natin? Only ordinary mitigating from that of what? What kind of aggravating? Only generic aggravating circumstances. There are several types of mitigating. Ordinary and privileged mitigating. Which one do you use to offset generic aggravating? It's only ordinary mitigating. What do you do with the privileged mitigating? You automatically reduce the penalty by a degree. No matter how many instances of aggravating circumstances present at that particular case. Hindi maapektuhan ang privilege mitigating. So kung nakita kayo, ang age of the child is above 15, below 18, acting with discernment, baba ka agad kayo by 1 degree. O kaya incomplete self-defense, merong unlawful aggression, may reasonable necessity. Diba, merong incomplete self-defense, pag majority yon are present, except basta andun ng unlawful aggression, okay? Privilege mitigating yun. So kung merong unlawful aggression at reasonable necessity or unlawful aggression plus lack of sufficient provocation, you lower it by 1 degree regardless of the presence of any aggravating. Okay? Kasi you will not apply that to the rule of offsetting. only an ordinary mitigating circumstance. What about aggravating circumstances? Anong ginagamit natin for the rule of offsetting? Only generic aggravating. Okay? So there are several types. There are qualifying aggravating circumstances. It changes the nature of the crime. Kanina we discussed that with the crime of murder. So you do not say the crime is homicide with a generic aggravating circumstance of treachery. No. Because the crime itself is already murder. Ba? You cannot say also if it's inherent. You cannot say the person is liable for malversation with a generic aggravating circumstance of abuse of public possession. No. Because inherent in malversation is the abuse of public possession. Now, evident premeditation. Evident premeditation is what? Okay, a qualifying aggravating circumstance in the crime of murder. Okay, it is inherent in the crime of robbery with force upon things. So, wag niyong gagamitin yan. So, meaning to say, just because may nakita kayo, okay, na aggravating circumstance, you will use that to offset. No. Because if it's a qualifying, if it is an inherent one, then you do not use that for the rule of offsetting. You will not use that. So dapat yan is only a generic aggravating. Okay? Now, sabi natin rules of offsetting. Kasi to get the maximum term of the indeterminate sentence, the penalty imposed by the RPC after appreciating the presence of the mitigating and aggravating circumstances or after applying the rule of offsetting. Okay. Now, di ba ang penalty merong divisible at indivisible penalty? Alam naman natin, disqualification sa Islaw is indivisible penalty. So pagka reclusion perpetua, huwag ka na mag-Islaw. You don't have to compute. Okay? If the rule in sa indivisible penalty, pag sinabing indivisible penalties, it does not have the minimum, medium, or maximum periods. Wala sila nun. Diba? So, capital punishment, death, wala. Reclusion perpetua, although it carries 20 years, 1 day to 40 years, Supreme Court said that it remains to be an indivisible penalty. So wala kayong maririnig na reclusion perpetua in its minimum or medium or maximum periods. So, okay, assuming that there is two mitigating circumstances, two ordinary mitigating circumstances present, and the penalty is reclusion perpetua for a specific crime. Okay? Do you apply Islaw? No. Okay? Do you apply the rule of offsetting? Hindi rin. Because it's what? An indivisible penalty. The only exception is that if there is a privilege mitigating. So, halimbawa, meron siyang reclusion perpetua. May isang privilege mitigating. So, naturally, diba, you will have to go lower by 1 degree. So what's 1 degree lower than reclusion temporal? It's what? Reclusion? What's 1 degree lower than reclusion perpetua? It's reclusion temporal, di ba? So, reclusion temporal, is it a divisible or indivisible penalty? It is a divisible penalty. Di ba? It has minimum, medium, and maximum period. So, you apply now the rule of offsetting. The divisible penalty rule. Okay? Now, let's go to specifically, let's have a review. To get the maximum term of the indeterminate sentence, divisible penalty. Aggravating, mitigating. 0 aggravating, 0 mitigating. Okay? What is the period? Period kasi divisible. So it's medium, right? Medium. So if there is 1 aggravating and 0 mitigating, that will be the maximum period. Right? Pagka 0 aggravating, 1 mitigating, then you will impose the minimum period. So, ang common mistakes ng mga students is pag 0-0 minimum, no. Pag 0-0 medium period. Pag 1 aggravating and 0 mitigating, maximum. Pag 0 aggravating, 1 mitigating, lower it to its minimum period. Paano, sir, if there are 2 or more mitigating circumstances? Halimbawa, 2 o 3. But there is no aggravating circumstance. What is, would it be in its minimum period? No. You lower it by 1 degree. Lower it by 1 degree. Now, ang tanong, sir, is this a privilege mitigating? Hindi siya privilege mitigating. Do not deem it as privilege mitigating. Although it only partakes of a privilege mitigating in the sense that the penalty will be reduced not in its minimum period, but the penalty will be reduced by 1 degree lower. Paano, sir? Kung 3 mitigating circumstances or 4 and there's 1 aggravating, common mistakes, ino-offset kagad nila. Gagawin nila, reduce it by 1 degree. No. The reduction by 1 degree lower is only applicable if there is 0. Okay? 0 aggravating. So if there's 1 aggravating, kahit 5 mitigating circumstances, just impose it in its minimum period. Okay? So now, if the penalty is reclusion temporal, a divisible penalty, and there are 2 mitigating circumstances as against 1 aggravating. Okay? Parang 6 lumalabas eh. There are 2 mitigating circumstances as against 1 aggravating. The penalty is reclusion temporal. How do you get the maximum term of the indeterminate sentence? Apply the rule of offsetting. So 2 mitigating circumstances as against 1. Okay? What will be the period? I-offset mo sila. That will result into minimum period. Mas marami ang mitigating. So how do you get the maximum term? It's reclusion. The maximum term of the indeterminate sentence is reclusion temporal in its minimum period. Or reclusion temporal, it's in its minimum period as the maximum term of the indeterminate sentence. Do not interchange one term from the other. Okay? Reclusion temporal in its minimum term. Okay? As the maximum term of the indeterminate sentence. So, walang problema. Okay. Assuming that the penalty is prison mayor. There's 1 voluntary surrender. There's also plea of guilt. Okay? And there's a use of superior strength. And the person is a habitual delinquent. Determine nyo muna yung circumstances. Voluntary surrender is what? Mitigating. Okay? Plea of guilt is what? Also a mitigating circumstance. So we already have two mitigating circumstances. Okay? Use of superior strength is an aggravating. So you have one aggravating. Okay? He's also habitual delinquent. So another aggravating. So you have two mitigating, two ordinary mitigating circumstances as against two aggravating circumstances. You offset two to two, then it will result into what? Medium period. Medium period. So what is the penalty? Prisión mayor in its medium period as the maximum term of the indeterminate sentence. Okay, sir, it's the penalty is again reclusion temporal. You have voluntary surrender. The age of the child is 15 years, is 17 years old, acting with discernment. The question is, determine the maximum term of the indeterminate sentence. Okay? You have to determine first the circumstances. What is voluntary surrender? Voluntary surrender is what? A mitigating circumstance. What type of mitigating? An ordinary mitigating. Second question, 17 years of age, acting with discernment. Okay, 17 years old, acting with discernment. What type of mitigating? It's a privilege mitigating. So, you have a case of one ordinary mitigating and one privilege. The penalty is reclusion temporal. What do you do? Ang una-una, okay, appreciate first the privilege mitigating. Regardless kung ano mang maraming presence yan, you appreciate first the presence of the privilege mitigating. What is the consequence? If there is a privilege mitigating from reclusion temporal, you lower, that's 1 degree lower. What's 1 degree lower than reclusion temporal? It's prisión mayor. Okay? Prisión mayor. Now you have one mitigating circumstance and there is no or zero aggravating. What will be the penalty? The penalty will be in its minimum period. So the correct answer is, diba, from reclusion temporal, you have one mitigating and one privilege. The maximum term of the indeterminate sentence is what? Prisión mayor, right? In its minimum period. Or you can restate it by saying prisión mayor in its minimum period as the maximum term of the indeterminate sentence. Okay? Correct. PM in its minimum. Okay? Ang dali lang, di ba? Ang dali lang siya. So, how do you get the minimum term? Simple lang yon. How do you get the minimum term? It's 1 degree lower than that imposed by the code. And what is the period? What is the period in the minimum term? The period of which, you cut and paste na lang yan. The period of which is upon the discretion of the court. Again, the period in the minimum term is what? The period of which is upon the discretion of the court. So, kanina, let's go back. Reclusion temporal. We say, we have reclusion temporal. You have two mitigating circumstances. You have one aggravating, generic aggravating. Okay? Ang tanong sa bar, determine the maximum term and the minimum term of the indeterminate sentence. So sinabi ko natin kanina, reclusion temporal, two ordinary mitigating and one aggravating. So what will be the maximum term? The maximum term is reclusion temporal in its minimum period, di ba? Reclusion temporal in its minimum period kasi 2 mitigating as 1 aggravating. Okay? Pag in-offset mo ya, minimum. Remember what I told you, pag 0-0 siya, hindi siya minimum. Pag 0-0 siya, okay, medium period. Okay, so 2 mitigating as 1 aggravating, you will arrive at the minimum period. So the maximum term of the indeterminate sentence is what? Reclusion temporal in its minimum period. Okay, correct. Ang sabi niya ni Mil Manguera, it's reclusion temporal in its minimum period. You're correct. Okay, so now we go to the minimum term. How do you get the minimum term of the indeterminate sentence? It's 1 degree lower. Yeah? So what's 1 degree lower than reclusion temporal? What's 1 degree lower than reclusion temporal? It is prisión mayor. Am I correct? Tama ba? 1 degree lower than reclusion temporal is prisión mayor. Okay, so that's the answer. The minimum term of the indeterminate sentence is prisión mayor, the period of which ang nakalagay dyan sa RPC within the range of the next penalty, next lower. But you will just say the period of which is upon the discretion of the court. Okay? The period of which is upon the discretion of the court. So the correct answer is maximum term of the indeterminate sentence is reclusion temporal. It's in its minimum period. While the minimum term, do not forget the use of minimum term. Do not say the minimum sentence. You will be incorrect. Hindi ka bibigyan ng full credit. So the minimum term of the indeterminate sentence is prisión mayor, the period of which is upon the discretion of the court. Again, cut and paste lang yon. The minimum term, okay, the period in the minimum term is what? Upon the discretion of the court. The period of which is upon the discretion of the court. So, madali lang siya. Yun lang yun. Now, welcome. Okay? Nag-thank you siya. So, welcome. Ngayon, ang tanong, pagka nag-compute ka, okay? Charles, yes. Pag nag-compute ka, and then bumaba ka na as your maximum term, kasi marami ng privilege mitigating, bumaba ka sa less than 1 year. Okay? As the maximum term. Okay? Pakita mo lang sa examiner that you know how to compute. But you would say, in the end, as your conclusion, the indeterminate sentence is not applicable. Why? Because the penalty is less than 1 year. The penalty is less than 1 year. Remember that. Okay? So, andali lang, di ba? Again, let me recall what I mentioned a while ago. Paano kung SPL, Special Penal Laws, okay, gumamit ng nomenclature of penalties under the Revised Penal Code? So, meron siyang mga reclusion perpetua, reclusion temporal. What formula, what rule are you going to use to determine the minimum term and the maximum term? You will use the rule under the Revised Penal Code and not under the RPC. the RPC and not the SPL. Ergo, kahit yan, special penal laws yan, meron ng rule of offsetting. You will now appreciate the mitigating as well as the aggravating circumstances to obtain the maximum term of the indeterminate sentence. Diba kanina sa SPL, wala tayong aggravating, walang mitigating. How do you get the maximum term again? In special penal laws, okay, do not exceed the maximum penalty imposed by the special penal law. Okay, how do you get the minimum term of the indeterminate sentence? Not lower than the minimum sentence imposed by the special penal laws. Anywhere in between is proper. If it exceeds, if it's lower, then it's not proper. With the RPC, how do you get the maximum term? Okay, the penalty imposed by the RPC after appreciating the presence of the mitigating and aggravating circumstances. How do you get the minimum term? It's 1 degree lower than that imposed by the code. Okay, the period of which is upon the discretion of the court. Now, when I check the test papers, ang common mistakes nyo is that what? Pag 0-0, ginagawa nyong minimum. Pag 0-0, medium. Tapos, pag check ko rin ng test papers, nilagyan ko ng 4 mitigating circumstances as against 1 generic aggravating. Ang ginawa, it lower by 1 degree. No, that's wrong. Again, let me emphasize that the lowering by 1 degree only happens when there is what? 0 aggravating circumstance. Pag may isang aggravating yan, kahit 5 pang mitigating, only in its minimum period. Yon ang common mistakes nyo. Okay. So exceeding na tayo ng 15 minutes. Last topic is about probation law. Now, probation law, as I've said, the convict need not go to jail. He will only have to report to the probation officer and meet the conditions of his probation. So there are disqualifications under probation. Do not interchange the disqualifications under probation from that of the RPC. Kung ang unang-unang disqualification under the law is penalty is death, reclusion perpetua, or life imprisonment. So probation is what? The penalty is higher than 6 years. If the penalty is higher than 6 years, he cannot avail of probation. Okay? So therefore, 6 years and below qualified, okay, to avail of probation. Remember that. Okay? So, kung RPC siya, hanggang prison correctional. If the penalty is prison mayor, disqualified. Why? Kasi ang prison mayor is 6 years, 1 day to 12 years. Hindi pa pwede. Okay. What is the other disqualifications under probation? Crime against national security. A person is convicted of rebellion. Now, ang tanong, dalawa. Can he avail of the benefit of his law? Second, can he avail of the benefit of probation? Under Islaw, pwede? No, because it's an express disqualification. Under probation, so you will now be confronted. Ano bang rebellion? Is it a crime against national security? No, it's not. It is a crime against public order. And so therefore, he can undergo, okay, probation, provided that the penalty is not higher than 6 years. Before the amendment of the probation law, inamendahan ng probation law, the disqualification is a crime against national security and public order. Ang public order was removed because of the amendment. So now it is only a crime against national security. Treason, di ba? Misprision of treason. But not rebellion. Because rebellion is what? A crime against public what? Order. So hindi pa pwede. Now, of course, if he availed previously of the benefit of probation, is already disqualified. So what is the most important here is appeal. Appeal. General rule, okay? These are two mutually exclusive remedies. You can only avail of probation or you can only avail of appeal. Once you filed an application for probation, effectively you waive your right to appeal. In the same manner, if you file an appeal, effectively you waive your right to probation. So, ganito. Andyan yan sa handout nyo. So the answer in that question is that there is no probation. He's not qualified for probation because he previously filed an appeal. Is there an exception? The case of Arnel versus Colinares. There's only an instance where although he already filed an appeal and yet the Supreme Court allowed him to avail of the benefit of probation. So this was asked several times in the bar exam. Ang nangyari ganito, he was convicted of the crime of frustrated homicide, si Colinares. And the penalty imposed against him is higher than 6 years. So, kaya niya bang i-avail of probation as a remedy? Hindi, di ba? The only remaining remedy for him is to file an appeal. So, Colinares filed an appeal. It reached the Supreme Court. Supreme Court sustained the judgment of conviction, but modified, the sentence. Instead of finding him guilty of frustrated homicide, is found to be guilty only of attempted homicide. Sabi ng Supreme Court, nagkamali ang RTC. And the penalty now imposed is only 2 years and 4 months. So compared with that frustrated homicide, higher than 6 years, now the penalty was reduced to 2 years and 4 months because he was only found guilty of attempted homicide. So when he secured already the judgment, nag-file siya ng probation. Now, this was opposed on the ground, on the principle that once a person already filed an appeal, diba, he cannot file a probation. Supreme Court ruling, teka muna, there was an erroneous judgment rendered by the RTC. Okay? Had the RTC imposed the proper judgment, which is 2 years and 4 months, then Colinares will have the option, 2 options, whether to file an appeal or probation. Now, in this case, because of the erroneous judgment, how can he file an appeal, a probation, where there was an erroneous judgment? So in this case, the Supreme Court allowed to file a probation, notwithstanding that there was previously an appeal filed. Okay? And this decision of the Supreme Court is now incorporated in the amendment of the probation law. Yon. So tapos na tayo, 4:20. So if you have any questions, pwede na siguro in writing, we will do that. Unless you would want to answer pa yung mga questions previously that we sent to you. Okay na to? Okay, so let me just say thank you for this opportunity to PALS and also to our watchers, to our future lawyers. Again, I say to you, don't forget, your dream. Okay, we are in trying times, but don't forget your dream because it's not yet the end of the world. Okay, magiging lawyers pa kayo. So you've got to strive hard to take all the opportunities that you have to study, and pray. Okay, so before we end up with the lecture, thank you very much. Sabi sa akin, welcome sa inyong lahat. Sana may natutunan kayo. Okay, sa lecture natin, especially sa Islam. Marami nagkakamaling mga students sa Islam. Okay, let me just give you a message coming from the Holy Scripture, which Jesus said. You have to remember this, especially now that we're confronted with COVID. Remember the message of Easter, which we just celebrated. He said that, peace I leave with you, my peace I give to you. I did not give to you as the world gives. Do not let your hearts be troubled, and do not let them be afraid. Do not let your hearts be troubled. Do not let your hearts be afraid. Okay? Let God give you His peace. That's in John 14:27. Sabi ni Jesus mismo yan. Sa Muslim brothers niyan, this is natin, this is from Prophet Isa himself, he said. And call on me in the day of trouble, I will deliver you, and you shall glorify me. Call on me when? In the day of trouble, what will happen? And I will deliver you. So God bless. Let's pray. Lord, you just follow me in these prayers. Lord, thank you for guiding me. And thank you for this day that we've learned. I pray that you will cover me with your love and your protection. I surrender my life to you. Forgive me of all my sins. And I accept you as my Savior. Okay? Thank you very much. And we love you and we praise you in Jesus' name. So, again, maraming salamat. Thank you sa mga nanonood, sa mga students from Polytechnic University of the Philippines, my students also from University of Makati School of Law, and from also Manila Adventist College. Thank you very much to all of you future lawyers. Okay, magiging lawyers kayo. We believe in you. That's why we have this free lecture series to show our support and our concern to you. Again, God bless. Stay safe. Be healthy. I'll see you, future lawyers.